Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. Say, Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana.
Hello and lovely good afternoon to you all out there. It's another Saturday afternoon, an opportunity for us to meet on BWTV to have the program The Community and the Law, brought to you by BWF Solicitors. The Community and the Law seeks to give you the empowerment to be able to look at all the immigration issues, all the legal issues, and have the confidence to face them head on. And whilst we're doing that with our trusted legal partners here in the community, we are talking about giving thanks to BWF Solicitors. It's the Community and the Law. And this afternoon, we're going to look at the reason many children applications are being refused when they put in search to come and join their skilled worker parents. So responsibility has reared its head again, and we'll be looking at that. But don't worry, there are answers. So that's why I invite you to come join us on the program, The Community and the Law, right here on.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate. Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Welcome once again and good afternoon. This is BWTV and we're bringing you the community and the law. Sole responsibility. The reason many child applications to join their skilled worker, that is care worker, parents or the people they depend on are being refused. We will be looking at this topic this afternoon on the program, so you would have to stay tuned in. Again, there are several updates that the community would have to have. And by courtesy of BWF Solicitors, we will be bringing you such updates on the program. Later on, we'll be looking at our quiz where we test our knowledge of the things that we learn on this program and all the other educational programs that BWF Solicitors bring us throughout the week. This week there was a very interesting comment on the page where somebody was looking at one of the comments and decided to throw in some comic relief. That is also very important, but listen, yeah, we do some serious stuff, so don't take the shine away from everybody's. But it's good to have some fun sometimes. So visit the pages of BWF Solicitors either on Facebook, YouTube, LinkedIn. If you have a WhatsApp network, you can throw it in there and share the knowledge that we give to you out there. My name is Ulriku Sefrimpon, and this afternoon I have the honor of hosting the senior partner of BWF Solicitors, Mr. Bernard, we call him Uncle Ben, and he is going to lead us to discuss the topic that I've put out, sole responsibility, the reason many child applications to join their skilled worker parents or people they depend on are refused. Why are they refusing that? It's come up and it's become very scary. So we thought it wise to look at why, then the how we can go around that, and also to meet that specification where it is that our applications will be successful. So, ladies and gentlemen, brothers and sisters, let me welcome Mr. Bernard Owusu, our guest and a senior partner for BWF Solicitors. And good afternoon.
Good afternoon, Kweku.
Thank you very much for joining us. We're so very privileged to be having you spend your Saturday afternoon with us. We may have had the chance to come to your office Monday to Friday, but Saturday, family time, we still have the opportunity of coming your way. So thank you very much.
Yeah, it's always my absolute pleasure to be serving the community. And I'm grateful that every day, every hour, every week, we are able to give them information, educate, and share knowledge. And for us, it's important that the community that we serve, we're able to provide the services that they require. Because what that does is that there are two categories of people that we look at. There are those who don't have the means to go to lawyers, but can read and support themselves. And then there are those who will have to go to lawyers. So we provide information to help them to make informed decisions about, applications, law, family, immigration, nationality, and the other bits and pieces. So any day we're called upon to serve the community, we do so with absolute joy. So I'm grateful to be here.
So those of you who have joined us online, what I ask you to do is to return the favor. Go to the BWF Solicitors Facebook and YouTube pages and all the social media platforms. Like the page, pick up the link and share. And then again, also subscribe to the notifications so that when we put out any content, you will be notified. And then you also have the opportunity of adding to your wealth of knowledge. This afternoon, BWF Solicitors want to say thank you to you once again. And let's go into what you gave us earlier in the week. And I would want you to be looking out for those things. It comes up Monday before midday. It's out there in the public domain, so you know what's going on. And immediately there's anything that comes up, BWF Solicitors puts it out there. Now, this week we're looking at a nugget which is about domestic abuse. Domestic abuse partners of skilled workers, students, and graduates can now apply for migrant victims of domestic abuse concession. In the latest Home Office guidance, migrant victims of domestic abuse concession, 16 February 2024, victims of domestic abuse may qualify for temporary permission to stay in the UK. The concession provides a short period of independent immigration status and financial support to these victims of domestic abuse, allowing them to leave an abusive relationship to a position of safety and support. This is from the Migrant Victims of Domestic Abuse concession of 16th February 2024. So our nugget is talking about people who are running away from situations that are abusive at home, and of course they need to be safe. They need to live their life in peace. They need to have that mental capacity and sereneness to be able to do what they have to do, and it becomes so um, difficult to express, but let me put it this way, forgive my expression. It becomes so annoying when there are children in there, because if the two adults have their own banter to pick up, yes, that's fine. But the children are so all the time affected. And to me, it burns my heart when people go through domestic abuse and the children suffer. There are people who just drive their children and their partners out of the homes, sometimes very late in the night. Where do you expect your child to go and live? Where do you expect your partner to go and live? Are you that mean or whatever it is? But you know, the society gives us the opportunity to have some respite and relief. And on the 16th of February, I should say that there's something that's been brought in to help alleviate some of these situations for people who are suffering. And I would want Uncle Ben to throw more light on it. The migrant victims of domestic abuse concession that was introduced on the 16th of February. What is it talking about?
Well, Kweku, I mean, anytime we talk about domestic abuse or domestic violence, it means the same thing. Domestic abuse or domestic violence, it's an abuse or violence in a domestic situation, usually will be between partners or families. And therefore, the immigration rules itself is also recognized for many, many years that where a partner or a family member has been abused, they can use that abuse to apply for settlement. There are factors that you will have to look at. So when we say domestic abuse or domestic violence, the definition itself is any action by a perpetrator on another person, either directly or indirectly, that causes them harm, fear, or distortment. So for example, we have financial abuse, we have emotional abuse, we have psychological abuse, we have sexual abuse, and then we have physical abuse. So it's not only the punch up, which is the domestic abuse, but it can be neglect, it can be emotional abuse, it can be insults, it can be psychological, it can be financial. Most often than not, if a migrant is suffering abuse, it will be because the other person who is a sponsor in the case. And therefore, they're using their superior status in the relationship to take something away from the sponsored person, and that doesn't allow them to enjoy the relationship. And we all know that in abusive relationship, the person who is a victim usually do not recognize the fact that they have to leave the relationship because of fear, because of dependence, and then also because of societal pressure. So what the Home Office has done over the years is that if you are in an abusive relationship, you could make an application to them. They will look at it. If they are satisfied with the evidence, they will grant you indefinite leave. So for example, if a partner arrives in the UK today, she will have to live here for 5 years to get indefinite leave to remain. But if she arrives today and tomorrow she suffers domestic abuse or domestic violence, and she can show that she suffered domestic violence, she will get indefinite leave straight away. However, the migrant victim domestic abuse concession, migrant victim domestic abuse, I got it right. Thank you. Which is the MVDAC. It sounds like a Zimbabwean political party. It's a new concession that is given to a different class of migrants.
Yeah, I can see that from the definition. It's for skilled workers.
Well, it's not only for skilled workers, but they've been added on. Okay. So skilled workers and short migrants. So yeah, when you ask a question, I'll explain further.
So why are they kind of taking that bit out and giving the preference to another group of people?
Okay. So before, as I said, for years and years and years, we've always had two routes to domestic violence. The concession is a short-term assistance to enable you get some sort of remedy, support, accommodation, and financial. And before, it only went to people who are on a long-term visas. So that would be spouses of settled partners, of refugees, of HM military personnel, and most recently of EU nationals. We didn't have students, we didn't have skilled workers or economic migrants on the concession.
Okay.
So the two factors that has now brought them about, it's the fact that now we have a bit more short-term migrants. We call economic migrants, like skilled workers and students. And the skilled workers, we know that up to September last year, only about 350,000 people have come in. So it's quite a significant number of people, and therefore the Home Office felt that it's necessary to give them the protection.
Okay.
We've always found, seen, heard, participated in resolution of domestic abuse circumstances. It can be insidious, it can be snide, but always the victim weighs their opportunity. So if the victim is afraid that if I report and my sponsor is not going to support my application, they might not report. All the domestic violence cases that I've dealt with, and in a typical year, we deal with a lot. It's taking them months, sometimes years, for them to arrive at the point where they want to seek help. And especially with men, they don't seek help because of sadly the potential embarrassment that is attached to it. And it's like a stigma. So a man who is complaining that, I've been abused by a woman, and, if I tell you some of the abuse, it could be a partner who wants sex every day. Even if the kids are there, the room structure is not soundproof, and the other partner is a noise maker, it becomes a big problem. And this partner says, no, I don't want to do this. Come on. We need to allow the kids to sleep first. And it's a constant thing that the woman wants it constantly. And then it becomes a punch-up, an abuse, an insult, psychological, throwing suitcases and clothing out of the window, from the flat onto the streets, calling the police, making false allegations. Now, these are instances that you come about, usually with migrants, and they won't report it. I'll give you my experience in 1994. There was a lady that I was supporting. She's come here. She's met a Jamaican bus driver who was a British citizen, and they lived in a house with a garden. And in winter time, I've said the story several times.
Yeah,
He won't allow her to use a bathroom. She'll have to bath in the garden, in the cold, freezing cold, no hot water. She's not allowed to turn on the heat. There was another one, a Ghanaian lady, who was not allowed to cook her soup, a typical light soup, peanut soup, granite soup, or even use cocoa butter, because her partner said that, he didn't like the smell. And anytime he left home, even if the postman comes or the gas person, those days they come and read meters, comes to read the meter. Anytime he comes from work, he wants to inspect her private, just to make sure that none of the men have touched her. I mean, so, I'm giving you examples of what can pass as domestic
violence,
abuse.
yeah.
Yes.
Well, this concession that's been given, does it have to pass a rigorous test of proof to show that I'm being abused, or a simple report to the police probably attending the scene and getting some evidence would pass as the person is suffering?
Okay, so let me categorize the two. What we have now is what we used to call DDVC, domestic violence concession. So it's a concession. At the concession stage, they don't look at any proof. So you go and say, I've suffered domestic violence. The reason why they don't look at evidence at that stage is basically at the time you're desperate for support, for accommodation, for finance. So the domestic violence or the domestic victim migrant concession is to a short-term support of 3 months for people who have made allegations of domestic abuse.
Okay.
Now, if you want to get a permanent status, you have to make an application under DDV, which is a domestic violence provisions under the immigration rules.
Right.
That is when they would test your evidence. So there's evidence which are mandatory. There's some evidence which is not mandatory. There's evidence that carries a lot of weight. Some evidence don't carry a lot of. But what we're discussing now, for students, skilled workers, for migrants, anybody who's being supported as a migrant in this country, clearly this one is to give you a short-term protection. So you get 3 months in your passport or visa. They will lift the no recourse to public funds, which means that you can claim benefit if you're not working, or you can get accommodation from the local authority, or usually from the Women's Refuge, because they provide support. They're charities, so they get support from the government, and they give support to people who are allowed to claim benefit. So it's a short-term protection so that you can leave that abusive relationship. And then whilst you have 90 days to think about the way forward and what you can do, you have this protection. So you don't have to worry that today, if Antobam, it's giving it to you in a domestic violence situation because you're here as a skilled worker and he or she is supporting you, you say, well, if I leave, how am I going to regularize my stay? I don't have any income. I don't have anywhere to stay. What am I going to do? This concession is saying that, well, if you make the application and it's made by a simple email, within a few weeks or days, sometimes days, less than a week, they will email you back and say you can claim benefit. The no recourse of public funds on you is being removed, and also your leave is being extended for another 90 days or 3 months. Then you have to make the full application. And that is what will give you the settlement. But unfortunately, for skilled workers and students, the 3 months is the end period for you, unless you switch to a different category. You cannot use the DDV or the domestic violence provisions to apply for settlement if you're a student dependent or a skilled migrant worker dependent.
So for that window, then you would have to find another route of going towards your original destination.
That's correct. So the focus of the Secretary of State is to provide interim support and protection for people who are going through abusive relationship. So interim support and protection, support for housing, support for food and maintenance. And then the 3 months gives you the leeway to do what you want to do. Then you come in and make your application. But for temporary migrants, and by temporary migrants, I mean students and skilled worker dependents, they cannot move on to the full-blown domestic violence grant, because that entitles you to settlement. Only people who are here as spouses of settled people, of British citizens, or people with indefinite leave, people with EU limited leave to remain, HM soldiers, and also refugees. These are the 5 people who can move on to the full-blown settlement status. But the others, you get a protection for 90 days, you can get accommodation, you can get women's refuge, protect you from this nasty person, or if you're a man, a man's refuge, because also men go through, because we deal with, not a lot, but we deal with men as well who have gone through the situation. So it's there for everyone, and I think it's a good opportunity. However, the women's protection groups in the UK have now set their eyes on the Secretary of State and say, well, why are you only giving 90 days to these 2 group people? Why can't they get settlement? Because as we know, in certain instances, if you leave your partner and you go back to the country where you came from, it's very likely that the extended family will then set on you and be nasty to you because you've gone to UK, you've gone to mess up the life of their son or daughter, you've called the police, they may have a criminal investigation or a caution, and maybe it's affected their job. So the family members are very angry against you.
Yeah.
And, these are things that the women are saying, well, we need to look at it carefully. And if there's a reason why this person cannot go back to their country because of the domestic violence situation, then the Secretary of State must also make some either permanent or semi-permanent situation for them to be able to stay here longer than the 90 days.
Well, I think it's tenable, and I know definitely yourself and other well-known lawyers and people who have the ability to do that will be pursuing that on behalf of people. So domestic abuse partners of skilled workers, students and the graduates can now apply for migrant victims of domestic abuse concession. This was made on the 16th of February 2024. Now, before we move on, there's another update that dropped earlier in the week. Care workers can no longer bring their dependents after the 10th of March 2024. The Home Office has published its new statement of changes in the immigration rules. Now, one of the things they have said in that is that care workers, unless those already on this route, are no longer allowed to bring their dependents after the 10th of March 2024. Applications made before 11th March 2024 will be decided in accordance with the current rules. If you want further detail, if you want further support and assistance, contact the experienced solicitors for more details. The numbers are 0208-493-7340 or 077-127-61884. Now, I think this was dropped earlier or the late part of last year. Earlier this year, we've mentioned that and said that from the 10th of March 2024, care workers can no longer bring their dependents. It's creating a lot of confusion in the community. People are asking, well, I have already applied, my dependents are not in yet. What's going to happen? It also dovetails into our discussion where people are applying for their children and dependents to join them, and they are being refused in droves and drabs. Why is that happening? What's the reasoning behind this? Maybe Uncle Ben will know. And big of a naive question, but let me ask. Why did we do this?
Okay, so first of all, in December, the government indicated that they had a 5-point policy to bring down net migration to the UK. And the biggest chunk of what they wanted to do was in relation to skilled workers, specifically people who are in the health and care industry. As at September, the applicants, we've had about 88,000 applicants under standard occupation code 6145, which is care workers. And then we've had about 27,000 for standard occupation code 6146, which is senior care workers, making about 112,000. That wouldn't have been a problem. They've brought in about 150,000 dependents to 250. So altogether, they are 350. So they brought in 250,000 dependents.
That's a lot.
Out of that, 66% is only coming from the healthcare industry. 66%. Out of all skilled migrants and dependents, 66% is coming from. And when you read the explanatory statement to what we call the Statement of Changes, HC 556, it clearly explains that the concern they have is the abuse of the system, the unreasonableness of the number of people that is coming in, and also the fact that it's a shortened occupation, so it's very easy for people to come. So what they've done now is that from the 11th of March, they are banning dependents from coming to join their sponsors in the UK. I know that it's created a lot of consternation, both with the NHS and also other health groups. Social media is rife with incidents of people who are concerned that it will discourage the carers from coming to provide the care. As of last year, we had over 3 million people who are waiting for care support. They needed almost about 350,000 people to provide care to these people. So there is a requirement for carers to come. But the government wants to make sure that if they are coming alone. Now, what is changed? What is changed is what we call the SW. Appendix SW is the skilled worker rules. And there's a 3.2, 5.2. I'll explain what I mean by the 3.2. And then there's Appendix CHI, which is a specific law that relates to children.
Okay.
When you read the law, and I'm going to adhere to show the law, yes, the one that I've done. I've prepared a video and I've also written an article. The article will be published anytime from now. And when you read the law, so this is the law, okay? Yes, this is the law. When you read the amending law, which is the new law which was published on the 19th of February, which comes into effect on the 11th of March, it makes a reference to SW3, SW29, and then it says that at SW29, insert SW29 1.A. Now, let's take our time and read it. I've carefully chosen this way, this path, because we don't have a consolidated law yet. And that is what is causing the confusion.
Okay.
So people think that there's a complete ban. The ban is not complete. Okay. It doesn't affect everyone. And this is why it doesn't affect everyone. So when you read it, and I make it broad slightly. So this is it. Okay? The law itself is SW29, right? This is for partners. It says that the applicant must be the partner of a person P. So anytime you see P, it's the sponsor who is going to bring their family member. So reference to P.
P, okay.
So when you see P, you know that P is a sponsor. So when you look at SW29, there's a mention of P. And it says P has permission on the skilled worker route.
Okay.
So P, we know who P is.
Who P is.
Let's go to the amending law, which is SW 2.929.1A. So P must have, let's read it.
It says P must not have
or
be applying for entry clearance or permission to stay as a skilled worker sponsored for a job in the occupation code 6145, care workers and home carers, or 6146, senior care workers.
Okay. If we pause there, and the conjunctive word, unless it's not there, it means everybody's banned.
Okay.
If the law stops there, then every care worker here is banned. After the 10th of March.
Okay. But this one, the unless is there.
Yes. So read unless.
Then it goes on to say, unless P.
Okay, stop there. Who is P?
The sponsor.
Okay. Who is the sponsor?
The person who has the permission to come on.
The skilled worker.
The skilled worker.
Okay. So start again. Unless
the skilled worker,
yes,
in this case, A, was or is being granted entry clearance or permission to stay as a skilled worker, sponsored in Occupation Code 6145, care workers and home carers, or 6146, senior care workers, under the rules in force before 11th March 2024.
Let's pause there. So the unless is, I used to call it adjective. It's not an adjective. It's a conjunctive word, a conjunction. So a conjunctive word is a word that qualifies a preceding phrase. So it is a conditional word. The condition that changes the ban. So there's a ban, but something else is changing the ban.
Right.
And what is changing the ban is that unless P, so where P is any of the following, A and B, the ban doesn't apply.
Okay.
So what is the A? A is was. Why did he say was? Because we're talking about present. Because it's making reference to 11th of March, which is in the future.
In the future.
So when you come to 11th of March, which is when this law will come into play, when they use the word was, it means in the past you were a skilled worker. And then it doesn't stop there, was. It didn't say was.
And they put a bracket, or
is being. So being is a continuing tense.
That has not been granted yet.
That's correct. That is correct. And for me, they are very significant. And it's a very difficult law to read. If you've done the rules of interpretation before, and as I've said, law is a very, very difficult area. It's really difficult in the sense that you need to understand the phrases and the language being used. And that is why English language is relevant to understanding of law. So once we've got a conjunctive word unless, then the post words, the words that are coming is was. So it's somebody, so who was on the route before the 11th of March? Who was on the route before the 11th of March? Anybody who's on the route now and still on the route was on the route. So they qualify. Okay. And then anybody who's made an application to be on the route and is still waiting for a decision, once they get a decision, even after the 11th of March, they can bring their dependent. That is why I brought this. This is for partners. Let's go to
the B.
The B, yes.
Yeah. Since the grant of entry clearance or permission to stay in A, P has continuously had permission as a skilled worker, sponsored in either or both these occupation codes, that is a 6145 and 6146, except that where paragraph 39E applies, the period of overstaying will be disregarded.
Okay, so what this is saying is that the person should have been a care worker or a senior care worker, and they should not have lost that entitlement. Or even if they've overstayed, under paragraph 39E of the immigration rules, if you've overstayed for less than 14 days, that overstay will be disregarded. That is what this is saying. But let's go, Ada, let's go down.
Okay. So requirements for a dependent child of a skilled worker. 1. SW 32A.1. The applicant must meet the following requirements for a dependent child in appendix children. 1. A. Relationship requirement, entry clearance and permission to stay. And 2B. Care requirement. And 3C. Age and independent life requirement.
Let's go on.
Relationship requirement, entry clearance and permission to stay. 1. CHI 3.1, where the application is for entry clearance or permission to stay. The applicant must be the child of a parent, P, where one of the following applies. A, P has permission on the same route the applicant is applying for, or 2B, P is at the same time applying for and is granted entry clearance or permission on the same route the applicant is applying for, or APPSW4 at the start of SW32A.1 for the applicant, substitute subject to SW29.1A, the applicant, APPSW5 after SW32A.1 insert SW32A.2 in the appendix children where CHI 3.1A or B refer to the applicant applying as a child of a person P. P must not be a skilled worker sponsored for a job in the occupation code 6145 care workers and home carers or 6146 senior care workers unless, and that conjunction comes again.
Okay, so if we stop there, then from the 11th of March, all care workers are banned from bringing their family members.
Okay.
But we don't stop there because there is a defining word, a conjunctive word, which is unless.
Okay. A, P, one was or is being granted entry clearance or permission to stay as a skilled worker sponsored in occupation code 6145 care workers and home carers or 6146 senior care workers under the rules in force before 11 March 2024. And 2, since the grant of entry clearance or permission to stay in 1, P has continuously had permission as a skilled worker sponsored in either or both these occupation codes, except that where paragraph 39E applies, that period of overstaying will be disregarded. Or B, the applicant was born in the UK.
Okay, and now you can take it off. So the conclusion is that the ban is on those who were not care workers or senior care workers as at the 10th of March, or those who have not made application to be care workers or senior care workers as at the 10th of March. The joy in this is that it protects those who are here. When you read the explanatory statement, which, I've got a hyperlink. Once I publish the article, that will come. The explanatory statement says that there is a transition protection. A transition protection is usually to protect people who are already on that route. And therefore, those who are already on that route, unless those who are already on that route, those are protected. So if you're here already as a care worker, senior care worker, if you've made an application already as a care worker or senior care worker, whether the application is granted before the 10th of March or not, the law says that you are protected. You can continue to bring your dependent family members.
It sounds a bit technical and a lot of paragraphs referring one to the other. And in law, as we've been made to understand, you can read the law and take one side as standing on its own. You have to look at the relationship, especially you have just giving us a lesson of that conjunctive word being there means that something is going contrary to what has been said in the previous paragraphs. That's a lot of lesson, and you can't get it anywhere apart from BWF Solicitors that gives us all the knowledge we need to have. Now, if you have any difficulty in understanding what we have put out, please contact BWF Solicitors on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters, North London, 0208 493 7340, or emergency number 077 127 61884. Again, this dovetails into the discussion I want us to have. And before we go on, we're going to be taking a break. But let me ask, they say that people can bring in their dependents, especially children. When I have had the permission to come to the UK to work, to satisfy the needs of those 3 million people that need care, I have left my children in the care of my husband. I have come in here. I run shifts. I come home. There's a lot of stress. I don't have anybody to talk to. So I need the comfort and that support network of my family around me. Let me go and bring my children. They say, no, we are refusing that because you don't have sole responsibility. And it's happening so much now. So are they giving us the permission with the right hand and taking it away with the left hand? We'll be right back to discuss that. And that is also very important to you as well, I know. So stick and stay, don't go away. BWF Solicitors, we're proud to say that you have helped us a lot and we want to say thank you to you. We'll be right back.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
And thank you for sticking with us. Those of you online, thank you. Let me quickly acknowledge some of you. Dauda, Sari, Tuhida Momo, Tilly Duma, thank you for joining us. Ezekiel Johnson, Theophilus Forcing, always ready to share the current home office guidance. Please listen to Uncle Ben. He is extremely endowed with legal knowledge. Nanaya, happy weekend. You say, Tilly, yes, we've seen you. Adepa Getisika, you are watching with us. Hildi Nana Abena Inyama Bolex is right here. Angie Nana Usu, big lady, thank you very much for your support. Kenneth Ofori Boateng and Tobam, we have you here online with us. Enchiwa Homeda Impieni, Ademununkum is here. Fraser Jones, Geoff McCormack, you are here with us. We have Inshaba Kwame, Mel Lipsy, Daniela Chimensa, good evening, everyone, you say. F. Asman is there. Margareta Dumensa, as usual. Daniela Chimensa, we've just read your message. We have one Maxwell Kweku Bethi and a host of others. Wumpini Adam is here. We have Kofi G, scrolling through, Biskuman, Joseph Chow, Godwin Ehis, Joshua Obeng, Kwame Louis, Joyce Asante, Rejoice Dente, Julie D. Ansu, Sue An, you're here. Kobe Richard Pia, Promise. Sankofa Tete Danso is watching with us. Counselor, how are you? I hope you're back from Ghana. Lee Carvalho is here. We have Franklin Atabwatima, Sikanku, Bernard Fosu, Wendy Morley, Bright Mulroy Noon, Janet Hall, Steve Bremer, Chris Cotter, Blair Thompson, Vladimir Gruev. We have Kwame Chimbwating, Davy Slave, Edmond Yaboa, Mark Young, you're watching. Abby Grace Mensa, John Williams, Brima Toure, I've mentioned your name. Tony Dick Kayinke, Uncle T is here. Demont McLaughlin, Kashan Khan, you're here. Kashan, how are you? Lily Obobisa, Mami Ndabozo, Charles Ohino Mensa, Scott Redmond, you are here. Scotty, how are you? Jordan Miller and Nana Ajimaya Sari Edu. Tom Terry is here. And Stuart Colley, George Krapa, Dominic Jedu, Ujen Wangchuk, Tia Savannah Ekela, Mike Trees. Mary Shuttleworth, Gordon, John Nisbet, so many of you, and I know you do what I usually ask you to do. When you come in, please send in a comment, say hello, and ask people to share when they come on. BWF Solicitors, we thank you. I'm going to go into our discussion, and I want everybody to follow us so closely. Well, there's something going on, and it's in the media as well. It's in the community. Now, let's look at this article The Guardian published a few days ago. Inhumane Home Office denying visas to children of migrant health workers. And Uncle Ben, with your permission, let me just read through a bit. Let's scroll down. The Home Office is systematically barring young children from joining their mothers in Britain, despite extensive proof the women are their primary caregivers. An Observer investigation. This is the Observer newspaper.
It's a Guardian.
It's a Guardian. And it says an Observer investigation. At least we're giving the credit to those who have contributed to this so that as we use it on our platform, we want to also do the disclaimer and say that it's for educative purposes, not for any commercial purpose. So, you know, under an opaque policy condemned as discriminatory and inhumane, the government has refused dozens of visas for children of migrant single mothers, many of whom came to work in the NHS or social care, saying there are no compelling reasons to grant them. The women left their children, some as young as 2, in the temporary care of relatives or friends while they moved to Britain from countries including Zimbabwe, Zambia, Kenya, South Africa, and India. Before leaving, they say they had been reassured by the employers that their children would be able to follow in line with the current immigration rules permitting healthcare workers to bring close family members. But when they applied for their children's visas, the applications were rejected. Now listen to this. In refusal letters seen by the Observer, the Home Office questioned why the children could not stay permanently with their grandparents or other relatives. In other cases, it said there was no reason why they could not go to live with their fathers, even though their mothers had sole custody of the fathers, or the fathers had not seen the children for years. Many of the letters addressed directly to the children conclude it was your mother's personal decision to depart for the UK, and you have not provided sufficient evidence to grant your visa on serious or compelling grounds. What is that? The cases have come to light weeks after the government announced a plan to slash immigration by placing restrictions on the dependence of the migrant workers, healthcare workers, and the controversial rules expected to be introduced this spring. That's the 11th of March we are talking about. Care workers coming to the UK will be barred from bringing their family members, while other health workers will have to earn £29,000 a year, rising to £38,700 in 2025 to be permitted to do so. Now, currently, they are not earning that much. So it means that children as young as 2 are being stranded back in their home countries. Well, it goes on and on and on, and some organizations have taken this one up. And I'm daring to take it up as well to ask the question, sole responsibility, why compelling circumstances are not what, and all those things. What is happening? Uncle Ben, you can feel the frustration in my voice.
Yes, it's very frustrating. Now, we are at the, at the high end of some of these cases. Over the last 2 days, I've had to deal with very emotional parents. One who was very, emotional. She was crying throughout our conversation. And there's one that started calling me today at 7:45 a.m. because she's received a similar letter and she wanted support. And, when I checked, she's called me about 20 times within 2 hours. And that tells you how desperate she was. And some of these emotions can be very frantic. It can be very debilitating. And clearly, it's so emotional that sometimes you really need to even insulate yourself because it can be very infectious. And if you're not careful, it takes away all your humanity sometimes, because when women are crying and emotional because they believe their child has been abandoned, it creates all sorts of problems. Now, so what's happening? And it wasn't like that before. It's only recently started. And I guess the reason is that the government realized that the dependents were coming here in their droves, and therefore there was, the need for somebody to suffer. And sadly, the kids took the brand, and as the Guardian refers to, a child of 2 years who's been separated from their mother, their sole caregiver. I was in court in Manchester about 2 weeks ago, and the issue was the sole responsibility. A mother who herself got pregnant at the age of 14, had a child at the age of 15. Her child is now at similar age, and her concern is that if she's not brought to join her here, the child may go through what she's gone through, which cut short her education, because at the age of 15, you will not have even written your GCSE, and therefore she couldn't continue her school. She's doing well now here. So Kweku, it's a problem for the community. And the reason why we want to deal with it as a major subject or topic is because there are things that you can do to cut down on the refusal. There are other things which is so unreasonable. Before, about 10 years ago, every Home Office refusal will attract a right of appeal. And the appeal will go to the Immigration Appellate Authority, and an independent judge will sit on the case. That is no longer the case. So if a child of a skilled migrant is refused, they will have to put in what we call an administrative review. It's a paper response to the decision, and the only reason why the decision may be successful is that they've either misread the law, misinterpreted the law, or haven't considered any evidence. That is the only way you can succeed. If it's because you feel that the decision is unreasonable, that is not a grounds for administrative review. And the administrative review is going to the Home Office to make the decision. This is the same body that has made the decision, and in most cases, rather wrong decision. 3, 4, 5 years ago, reports that was written about Home Office decision, almost about 45% were wrong decisions. So we can safely say that in instances of this nature, at least about half of the decision are wrong decisions. So, and the other sad part of this is that even when you put in an administrative review, they don't deal with it instantly. It takes months. I mean, we've got one that we've been waiting for 6 months plus. There's another one that we've waited for 8 months. The last email we received from them when we launched a formal legal process, they said it can take up to a year. Now, it's an indirect way of saying we don't want you to bring your child. And it's unnerving. It's unnerving. And, even the emotional cry on the telephone, sometimes when I go to bed, I hear it in my ear. No, it's serious. That is how emotional some of these women can be. And they want you to use all the arsenal at your disposal to fight on their behalf. That is why we're here. But it can be very difficult.
Let's unpick the reasons they give. Why are they refusing them?
I wish I could share one reason with you. I haven't redacted it, so I will not even attempt to redact it now. It takes a lot of work. There's one that is literally come on my email. And the reason they refused is that in one breath, if you've read a Guardian newspaper, they will say, well, your father, who is not in your life, should have written a letter to say that he's not in your life.
This father is AWOL.
Now, when you do that, they will write back and say that, well, for the father to have written to say this, it means the father is in your life.
Obvious.
And it's rather unfortunate that we don't have a full appeal process. If you exhaust the administrative review, you can go for judicial review, which then goes to an independent judge at the upper tribunal. It's costly, is time consuming, and clearly between the date of the decision and the date that you may have a hearing at the upper tribunal for judicial review, potentially looking about a year plus, which means that your child has been separated from you. And some of these decisions, the mothers only left a few months ago, maybe 2 months ago, 3 months ago. This child has lived with their mother throughout their life. The father hasn't played any role. There's evidence that the father doesn't play any role in the child's life. When you read the policy guidance on sole responsibility, custody is not the same thing as sole responsibility. Sole responsibility means the parent or the absent parent has not abdicated their responsibility. They have delegated their responsibility. The relevant case law is a case of TDMN. And what the case says is that every case wins or falls on its own facts. What you must show is that the child's education, the child's health, the child's social network, religious upbringing, every aspect of the child's life, the decision is taken by you. But also the guidance notes recognize that physically you're not there to take the decision. So you take the decision through other people.
Okay.
And the way you exhibit taking the decision through other people is when you're taking the decision through other people, you do that by WhatsApp messages, by emails, by text messages, by money transfer and receipts and all those things. So this is what I always advise my clients. If you know that when you come here as a skilled migrant, you go for your child, you need to start documenting what you do with your child.
That's it.
Either in pictorial form or taking school letters and everything, participating in the child's education. And when you've left and come to the UK, you must continue to be interested in the child's life. So for example, if you call the school, usually you call the school using a WhatsApp call. You need to document that. If you send money directly to the school and it's gone by Momo or bank transfer, you need to document that. Where the other parent is alive, that is what causes these problems. So the other parent may be in the same country or his whereabouts may be unknown. The Home Office will want you to show that the other parent is not in the child's life. Kweku, how do you prove a negative? It's extremely difficult.
Yeah.
To prove, you can prove a positive. When you're doing something, you can prove it. But when you're not doing something, how do you prove that a man is not in the child's life? And therefore, what they do is that they come back to you and say, you've not been able to show us that the father is not in the child's life. You've not been able to show us that this child cannot live without you. You've not been able to show us that you cannot continue to have video calls with your child and send money for the child. It's broad. The solution is what we are here to talk about. We've identified the problems. We've identified the emotional aspect of this problem, and it can damage parents, especially mothers.
That's
it really, I've seen it firsthand where a mother is beside herself, crying and emotional. She just told me this morning, she said, Uncle Ben, I received this decision last night. I haven't slept last night. That's why I've been calling you since 7:30. So it's a problem which ought to be dealt with. And the 7-point remedy that we propose are this.
Okay.
Number one, always have evidence of what you do with your child and for your child. The evidence I'm talking about is the calls you make to your child, the interaction you have with the child's school, the instruction you give to the child's caregiver, and sometimes the physical presence that you have when you travel to see the child. 2, the child's medicals and health visits should be of interest to you. So if the child suffers from malaria or some other illness, if they go to the pharmacy to see a pharmacist or the chemist to see a chemist, or they go to a compound chip to see a compound chip expert, or to the clinic, and if it's in the village, it might be some small health center. You need to be able to speak to the people in charge and exhibit it. How do you exhibit it? So, well, When you call them, very likely that, they will tell you what is wrong with the child. You can explain to them that, can I have a chat or even a voice text interaction with you?
Yeah.
You can save that. When you're paying the hospital bill, it's very likely that the hospital might not have a momo. So the money will go through somebody. It might be the caregiver, or it might be the nurse or the healthcare assistant at the health facility who you're going to pay this money to. But when you send the money, they receive it on their phone or in their account, or they go and collect it from a vendor. The receipt that they've received, let them send it to you.
Okay.
Let them send the receipt.
There's another thing I've realized. Some of these money transfer apps that we have, they ask you for a reference and the reason why you are sending. So the reason why you're sending will come as a drop down. Family, business, paying for an invoice, and the rest of it. Then again, they will also provide you the opportunity to put in a reference. So you could put in a reference to say, Kwesi Menu's school fees, Kwesi Menu's hospital bill. Then you can do a screenshot of that and save.
That is helpful. Now, I'm going to tout one of our community providers. Unity Link will always send you an email. Tap, my own young brother, Nana Kwame, will also send you an email. Every month they send you a statement. And then the other wave or ways or whatever they call them, you will have a receipt by email. What you don't have is your bank account showing that this money left your bank account. And what you don't have is a receipt of the money from the recipient. So there are other things that people don't add. This conversation is to tell them what to add. So when I send money to my driver, it comes from a card. It's either a debit card. Some people will have a Monzo account. So if it's Halifax, MasterCard, or Visa card, it will come from the card, which means it's coming from a bank account. The bank account will show that on this date, I transferred £10 to Waze, to TapTap, or to Unity Link. The Waze receipt will show that on this day, you transferred £20 to somebody in Ghana. So already the Waze £20 and my bank statement £20, they collaborate each other. So you've got that. What you don't have is the money reaching the recipient. So once the recipient receives the money, they can give you a screenshot, either their Momo statement, or when they collect it from a vendor, they will give them a receipt. They can show it to you. It hasn't finished. That money is used to pay something. It might be medicine, it might be hospital cost, it might be school uniform, it might be trainers, it must be shoes, it must be transport cost. So when you pay the school fees, so I've sent, let's say, £200, which is 3,000 Ghana, to pay my son's school fees for the year. Take the receipt, which tallies with the money that was sent. It may be that you sent more money than the school fees, but at least we know that the amount you sent is more than the school fees. So if you send 3,000 and the school fees is 1,005, it's a plausible explanation, because the law, the weight of evidence and the burden of proof is on you. But the standard of proof is not a criminal standard. It is the civil standard, which is a preponderance of evidence or the reasonable cause. So is it more likely that the 3,000 are sent, 1,005 of that was used to pay Nanawusu's school fees? I've got a school receipt. I've got a letter from the school which says that I send money through this person who pays the school fees. I've got a headmaster who's written a letter to say that I called the school to check on my son. And then over the few months that I've been here, I've been sending money. The health post, I've got the same receipts and invoices and letter from the health post. The church that I used to go to, I can show that I was baptized in this church. I can also show that we've got pictures that every Sunday we go to SDA or Assemblies of God or Central Gospel Church. Whilst I was there, that's what we're doing. I've got pictures with my children going to church or going to birthdays or even celebrating their birthdays. I've now got a letter from SDA Church or the Adventist Church or Presbyterian Church, which says that Nana Wusu was a member of this church when he was in Ghana. We know he's now in the UK. His child still attends the church, and sometimes he calls to check up whether the child comes to church. That letter, although it's self-serving, is an independent evidence. The guidance note says that if you produce anything which is independent in support of your application, they have to look at it. The fact that they look at it doesn't mean that they will give a heavy weight, but they will have to look at it. I have seen some of the decisions which does not give weight to any of this evidence at all. And therefore, when you're doing your application and you've got all these letters from the school, the scouts, the girls' guide, the brigade, the swimming pool, the football club, the health centers, the church, the imams, they've all written. Are we saying all these people are lying? Is it a case that all these professionals, religious leaders, doctors, pharmacists, chemists, nurses, teachers, headmasters, professors, lecturers, that they've all ganged up to lie? Is that what we're saying? And the more evidence you have, the likely the success of the application. Please, and I think we should all focus here. If you say that the other parent is not in the life of the child, don't go and collect any consent from
but if the person is not there, why are you going to get the evidence?
Because some of our community members are being told to go and take consent from the other parent. You are the parent. You are in the UK. When we say parental responsibility rests with a natural parent. In the UK, if your name appears on a birth certificate, you automatically have parental responsibility. So when they make a decision and they say that the evidence you've brought, we've seen it, we've read it, we understand it, we know it's genuine, but it doesn't show that you have parental responsibility. It makes me wake up as to the sort of officers and case workers who are reading and deciding some of these cases. If a case worker doesn't understand that a natural parent automatically has parental responsibility and it can only be taken away by a law court, then it worries me. Somebody goes to court and they are here, they apply for custody order. Custody is not the same as sole responsibility. The fact that you have a custody order, you're physically not there. So the custody order is just in name. It doesn't prove the things you do. What proves the things you do are the things that I've mentioned. The interaction with your child, the telephone calls, the telephone call with the school, evidence from the school, the money transfer receipts, the payment receipts, the letter from the church, letter from hospital. These are the things that shows that you still think about your child. And if you can spare some time, even if you've been here for a few months, before you make the application, go to Ghana, go to Zimbabwe, go to India, go to Jamaica for a week or so. Take a week's holiday and go. I know that tickets can be very expensive sometimes, but all this preparation is to make sure that you have an unblemished application and that the chances of the application succeeding is higher with all the steps that we have today enumerated.
A very straightforward question, Uncle Ben. These refusals that have been happening in these few days, can we get them reversed? Can we succeed against them?
Yeah. Well, you can succeed. The waiting time for an administrative review on a skilled worker route, there's no service standard.
Okay.
There's no service standard. Where the Home Office has no service standard, you're potentially looking at over 6 months. Before, they used to respond quickly within a matter of weeks, not more than a month. Now we've got some which has been there 3 months, even 6 months, and we haven't got a decision. There are other things that we are going to start to do, and I'm happy to tell other lawyers, because I know some lawyers are watching us and they are listening. We need to start issuing pre-action protocols against the delay.
Okay.
And when we issue the pre-action protocol against the delay, we shouldn't stop there. Because I know normally when you do a pre-action protocol, which is called a PAP, which is a requirement under the civil proceedings rules, you cannot go to a judicial review court without giving the other party an opportunity to respond to your concerns. When they respond, they say that there's no service standard. Well, we're not saying we're saying there's a delay. Whether there's a service standard or not, the fact that consideration of a simple administrative review is taking 3 months or 6 months is an inordinate period and it's unreasonable. And for that reason, you can go to court. I mean, there's a recent decision, it's a high court decision, but there's been previous decisions which says that a delay of more than 6 months can be actionable. And it's therefore important that when we make these applications, we should explain to our clients that when it gets to administrative review, it can delay, but they should be prepared to fight it and possibly go to the upper tribunal and have the cases expedited.
Well, you can do it. The next question, probably before the break, but I just want to remind you that if you have joined us and you stayed with us, it is very, very valuable to us. So give us a like and share the page so the algorithm will look nice. We've got several comments on the platform that we'll be picking up for Uncle Ben to address for us. Naomi Buami will be coming back to your question pretty shortly. Those of you who have on Facebook, YouTube, and everything, please keep them on there. You can send a text to 0739920848 or WhatsApp audio notes to our WhatsApp platform 079504227780. We're looking at sole responsibility. The reason many child applications to join their skilled worker parents or guardians are refused. Kubera has identified those and is giving us the assurance that yes, we can do something about it. And definitely before you put in that application, he's also told us the steps that we need to follow to make sure that we put in an application that will be successful. BWF Solicitors, thank you very much. But when we come back immediately, I'll be asking the question, can we, instead of appealing, make a fresh application? Is that tenable? Is that feasible? We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
12 months.
Welcome back, and thank you for staying. I've got a lot of the concerns and questions, and I'll be putting them to Uncle Ben. We have a few of them on the platform we'll be picking up as well. So if you are having any concern, any question concerning the topic we have treated or any other thing, please call in now on 0208 493-7345 or send a text to 0739920848 or WhatsApp to 079504227780. Uncle Ben, thank you for sticking and staying. And remember, we're doing that courtesy BWF Solicitors, our trusted partners when it comes to the law. Call them 0208-493-7340 Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Can we make a fresh application when these refusals come in, or we may have to wait and appeal?
Well, you can always make a fresh application even when you've submitted administrative review. If you look at the administrative review guidance, it says that if you submit an application, a fresh application,
Mm-hmm.
your administrative review will automatically be withdrawn. At the moment, it's taking about a year. The service standard is about a year, and you can make a fresh application. But if you're making a fresh application, you're not just making a fresh application, but you're also addressing the concerns that they've expressed in the refusal letter.
Okay.
Thankfully, the visa fee for skilled migrant dependent is not too expensive. It's expensive, but not too expensive. It's not in the thousands. It's below 1,000. I think it's if it's not a priority, it's just about $500 or thereabout. I may be wrong, but it's not very, very expensive. So you can always reapply. But again, when you're reapplying, make sure that your lawyer is dealing with the issues at stake, which is basically the reasons why they refused you. Most of the reasons are unjustifiable, that I can say. I mean, you know, maybe somebody might say, well, because you're a lawyer, you say that. No, not because I'm a lawyer, because when you have a situation where the person is entitled to a full, proper right of appeal and not a stack against administrative review, which goes to the same organization to decide whether or not they've made a mistake, and they are taking over a year to look at it. They don't come back to you with proper responses. They just say, we've upheld the decision against you, because what you are trying to say, it's not within the remit of administrative review. I wish that we could go straight away to judicial review. But of course, if there is a statutory right of redress, you cannot use judicial review until you've exhausted that particular statutory right of redress. This is what I will say to everyone. The issue can be dealt with by providing evidence. When you're providing evidence, it must be evidence that convinces. So if you're providing a new birth certificate and the child is already in their teens, you must know that it's likely to be refused. So you must provide either contemporaneous documents from when the child was born, or you get a DNA. Again, if you've just been here for a few months, you need to document your life in the country where you were living with your child. So everything you've done with a child whilst you were in that country should be documented, usually by way of photographs and stuff like that. But above all, when you're making your application, don't just complete the application forms. Write an explanatory letter. And it can be something simple as, dear sir or madam, I'm making this application for my child to join me because the caregiver is leaving the country. Or there was a temporary arrangement between myself and the caregiver. And the understanding was that I was coming to the UK. Once I've settled in work and found suitable accommodation, I was going to go for my child. Once you write a letter, you also have to explain all the evidence that you attach. It's not every evidence they understand. So you need to explain the evidence that you've attached to the application. And you can do this in a written form. Upload the letter as part of the upload, because when you make your application, you have to upload the supporting documents. Upload the cover letter, and you can go into detail. I've seen people who've made their own application and written about 7-page letters to explain the background to the case. And in those instances, you know, they are making a pitch for a win. Because as we can see, people are being refused for very frivolous reasons and unjustifiable reasons. So to prevent that, you need to fight for your case.
Okay. If you're on here and you want to come on board and ask lawyer questions, 0208-493-7345. I think prior to us going for the break, we had Naomi. Is it Naomi? Yes. Bring in a question. And then let's have a look at this. A friend of mine came to the UK as a student partner, but she divorced. She met another guy whom they have got a child together. The current partner is a British citizen. The lady still has 1.5 years remaining in her student partner visa. My question is it possible for her to use the child to apply for a 10-year root family visa while she still has 1.5 years visa as a partner?
Well, when you're here as a migrant and your circumstance change, you need to let the Home Office know. Another way of letting the Home Office know is making an application.
Mm-hmm.
I mean, she's currently on a non-settlement visa. It doesn't lead to settlement. And every time that counts on that non-settlement visa may not count towards her settlement time. So the earlier she switch, the better. Yes, if she's got a child and she's got a visa, she can switch onto the 5-year route, not a 10-year. The 10-year is usually for people who do not meet the rules. But from what you've said, she can have met the rules. However, if this person is still married to that student,
Mm-hmm.
the child is not the child of her new partner if they are still married to the other partner.
Yeah.
And it raises issues about what we call Section 50A of the British Nationality Act, who is the father of the child, and why the child in law may not be British, but in biology, the child is British. So you need to be careful. I'll say speak to someone, speak to a lawyer. It can be any lawyer. You can speak to any lawyer who can help you deal with that part. Just be careful of what you put out, because clearly if you're already married, then there could be potential legal hurdles to climb.
Well, another one here, we have Uncle Ben, please. What if the children are with Real Man? Your question looks like it's a continuation of something. I don't know whether we can pick that, but let's see what he says. What if the children are with your mom, whom you only had children with and not married, but currently stays in the UK with your wife, and wish to bring your children, whom you added as partner, as dependent, while coming to the UK as a care assistant? I can't really make a meaning of that. So, Real Man, if you could give us a proper question, I think this probably is a continuation of something you wanted to ask earlier. Please help us with that. Let's go to the next one.
Let me answer that.
Okay, Uncle Ben will answer that.
So this person has children with another woman. They were never married. He now lives here with another woman. But the children are living with their mom. Now, when you look at paragraph 32(1) of the immigration rules, SW and CIH 3.2, these are issues that you need to deal with. Clearly, in this case, you will struggle to show that you have sole responsibility for the children. And therefore, bringing the children whilst they live with the other parent in the country they live, it's almost insurmountable. It's very difficult to bring the children because there will be no evidence of sole responsibility. If they were living with another family member or a friend, then the issue is between you and that friend or that family member. And because you've delegated and not abdicated your responsibilities, you can show sole responsibility.
Okay. This one says, lawyer, I hope you are doing well. Please, my humble question is, I married in 2009 and I made an application to the Home Office 2012. And I was refused, and I made an appeal, and I was granted 5 years in 2015. I got my permanent residence June 2019. Please, can I apply for my naturalization and citizenship?
Yes, you can. When you look at section 6.1 and 6.2 of the British Nationality Act, it covers people who are adults are making application as naturalization. 6.1 is somebody who's applying in their own right, so they have to show that they've lived there lawfully for 5 years, and that since they got their settlement, there's been 12 months interval. If it's a 6.2 application, they have to show that they've lived there legally for 3 years, and that at the date of the application, they have indefinite leave. So yes, she had indefinite leave to remain in 2019. She can apply.
I have a voice note here. It's in the Ghanaian language. I'll play it and give a summary of a question for the wider audience. Then I'll ask Uncle Ben to help us with it.
Wako memo happy Sabbath. Me pacho. Me person me bisa wasembi. Se Yɛmfa ne sɛ mepɛ sɛ megyae awareɛ na mede kɔ court na ɛgu so a yɛreka na madwere saa sesa na sɛ mempɛ sɛ megyae pii mu a ɛyɛ mmara sɛ ɛwɔ sɛ agyapade a me ne bɛrima no ayɛ ɛne mmɔfra a me ne bɛrima no awoɔ no sɛ meka sɛ megyae divorce process na metumi ahwere saa nneɛma no nyinaa. Deɛ mama bisa wo ne sɛ na sɛ mahu sɛ ɛyɛ a ade bɛto so no ɔne lawyers yɛdili nti mepɛ nokora a ɛwɔ mu ɛtie. Meda ase. Bye-bye.
Well, for the purpose of those who may not understand, this lady is trying to find out that if she filed for divorce, and as the process is ongoing, she changes her mind and will not want to continue. The question is she going to lose the property she has made together and acquired together with the man whilst the marriage was ongoing? And she deciding not to continue with the divorce, would it have any impact on the properties that they have acquired together?
Well, so first of all, if you make an application for divorce and the other party is served and the court has not dissolved the marriage finally, so you haven't received a final order. Before we used to call it decree absolute. It's now called a final order. Even if you receive a conditional order, you can recant and withdraw the application. But because it's been served on the other party, who will be the respondent in this case, you will need leave of the court. So you have to make an application to the court to withdraw. Now, I had a question whether it affects property rights. The Matrimonial Causes Act clearly makes provision under Section 25 for distribution of assets whilst a marriage dissolution is ongoing. If there is no marriage dissolution, either nullity or divorce, then the Matrimonial Causes Act do not play a part.
Okay.
So whoever retains the rights in the property will be both husband and wife, because just the fact that somebody bought a property in their name doesn't mean that they own that. They might have a legal entitlement, and we call it possessory right, but you may also have what we call right in law, and therefore the person is holding it in trust for you, although physically your name is not on the deed. Every person who is married, if an asset is acquired during the marriage, potentially will have a claim on that property. So whether she puts in a divorce and continue or withdraws it, if her husband has right, that right will not be extinguished by the fact that she's filed and withdrawn. And if he didn't have right, that right will not be revived because she filed and withdrew. For every process within the Matrimonial Causes Act, there are rights and there are responsibilities. What I always advise people is that you need to be very careful when it comes to the issue of distribution of assets or financial settlement. You must always engage a lawyer, because if you're not careful and you plod on as if you understand what is going on, because these things can be emotional. I've seen women come to me and say, I don't want to divorce him. Meanwhile, the divorce is going on. The man has filed, and they say, I don't want to divorce. And therefore, they don't even want to talk about the property. By the time they realize, the man is going to marry another woman, and it means that that woman that they've married will have rights in the property, although it will be within the portion of the man. But it becomes very difficult when it comes to needs assessment under Section 25, because the man would have had a new family, and the needs of the children will be calculated when it comes to needs assessment in financial settlement under Section 25.
All right. Thank you, lawyer. So the person that brought in, that's your answer. Thank you very much. We have Abigail also coming up with a question. Please, I'm a skilled worker and have accommodation on site at my care home. Now, I'm sure I can bring my family anytime after March. I want to finalize the immigration issues, and when all is clear, I get a full house. Please, will housing in any way affect my dependence application?
Well, every person you want to bring here, you need to prove that there is adequate accommodation.
Okay.
The word in the Home Office rules is adequate accommodation. The assessment is done using the Part 10 of the Housing Act.
Mm-hmm.
And Part 10, when you go, the schedule will give you an estimate of what one room will be, what two rooms will be. So rooms are not only bedrooms, they are bedrooms and living area. So if you've got a dining area and a TV area and you've got one bedroom, you've got 3 rooms. And we know under Part 10 that for every child who is under 1, they are counted as 0. For a child under 10, they are counted as half.
Mm-hmm.
For children over 12 of opposite sex cannot share one room. So these are nuances that you have to look at. But the law you have to look at is whether or not there is adequate accommodation.
If you would want to join us by voice, the number is 0208-493-7345. Doris says, lawyer, please, if you came to the UK with your student husband, but now on a skilled worker route, but pregnant for a British citizen, can you switch to the 10-year route, or you need to divorce your husband first?
Okay, well, let's be very careful here. Let's be extremely careful. The British law in this area is the Immigration Rules and the British Nationality Act. Your partner, current partner, is not your husband, but you are married to someone else. Under Section 50A of the British Nationality Act, if you give birth whilst married to another person,
mm-hmm.
although biologically that man is not the father of the child, the definition of a father of a child under the British Nationality Act includes the husband of the mother at the time the child was born. So although you say that you came here as a dependent of a student visa holder, I assume that you're still married to that person.
Mm-hmm.
That's why you ask whether you should divorce him. If you're pregnant with another man or for another man, you must be very careful that at the date you give birth, you should be free from your husband, which means that you're divorced. Else your child will be the child of that student, which means that for your child to get a British passport, they will have to complete a form called Form UKF. Pay money, sometimes it's free. You can ask for a free application, but it could take up to 6 months. And it means your child has been registered as a British citizen instead of acquiring citizenship automatically.
0208-493-7345. Rejoice also comes up with a question. I have a friend who brought their son here in 2018 and was given 10 years private life route, but his parents are going to apply for indefinite leave this year. The son came here at 20. Can the son also apply for indefinite leave, or has to complete the 10 years?
Okay, so if you are a youth, and the definition of a youth is anybody between the ages of 18 and 25, and you've lived here lawfully for 5 years, you may be able to apply for indefinite leave. There's a question whether it has to be a complete private life, but the rules are such that you can also use the explanatory statement to say that if somebody who's been here purely on private life for 5 years can qualify, and the intention is to cover people like me, I've lived here for lawfully for more than 5 years. I'm a youth because I'm 20, I'm under 25, but I'm above 18. And if I can show that I've lived here lawfully for 5 years, I should qualify for indefinite leave. I would say he should be able to apply, yes.
Okay. I think Abigail has sent a continuing question. Let's see. Okay, lawyer, thanks. But in that case, should I get the adequate accommodation before I file my application? Or I can do that and get the accommodation when I get a decision?
No, you should get proof of that accommodation. So I know some estate agents will sign a contract with you for the contract to start. So we call it delayed tenancy.
Okay.
So the delayed tenancy will start either in a week's time, in a month's time, or in 2 months' time. Because it may be that somebody's already there, the person is going to leave, you will then take over. But you cannot make application without evidence of adequate accommodation and maintenance. And therefore, whether you rent a house, a 3-bedroom house now, whatever it is, you must have the evidence to show. And usually will be a tenancy agreement or a letter from the landlord or the letting agent.
Okay. BWF Solicitors are trusted partners when it comes to the law. They are located on the 4th floor of the Anna House, 214 to 218, Tottenham High Road, 7 Sisters, London, N15 4NP. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. Visit them. But if you want to meet any of the lawyers over the weekend, you have to book an appointment. This afternoon, they have, as usual, supported us to bring you the community and the law. And we've looked at sole responsibility. There are even many child applications to join their skilled worker parents or people they depend on are refused. He's taking us through some of the steps to take to make sure that those applications are successful. And if you've been refused, you will also have the chance to make an administrative review, which might take a long time, but still worth doing it. And I asked the question that, can I make a fresh application? The answer he gave was very refreshing. It says, yes, for anything you can make a fresh application, but make sure the things they used in refusing you in the previous one, you have addressed all of that. Evidence is the name of the game. Remember that all the time. Evidence is the name of the game. Let's see if we have any comment, question. If not, we'll be taking a quick break. Then we'll come back to do our quiz. But in the absence of that, I think let me go back to the nugget. It will help people come to the realization that we have to answer that question really. Domestic abused partners of skilled workers, students, and graduates can now apply for Migrant Victims of Domestic Abuse Concession, MVDAC. In the latest Home Office guidance, Migrant Victims of Domestic Abuse Concession, 16 February 2024, victims of domestic abuse may qualify for temporary permission to stay in the UK. The concession provides a short period of independent immigration status and financial support to those victims of domestic abuse, allowing them to leave an abusive relationship to a position of safety and support. And come in, quick one before we go on the break. In the second, in fact, the first paragraph where it says victims of domestic abuse may qualify. I am cognizant of the fact that certain words have certain meanings in law. That it says may, so it means that it is not a given. There could be some criteria people have to satisfy. Is that correct?
Yes. So the broad outliner for the 4 areas is those who have settlement, those who are British citizens, those who are refugees, those who are in the army, and then those who are EU nationals. And then the additions are students and then skilled workers. So that's 7 areas. So the fact that you're here as a migrant, if you're not one of those, then clearly you cannot go on that route.
Okay, well, so it's clear as daylight. Somebody's just said that Sandra and Miss Papeku are saying that they like the fact that evidence is the name of the game. Well, it is. So that's what it is. Because sometimes when these case workers are following the guidelines, I don't know sometimes whether they slept on the left-hand side or the right. They make certain decisions that don't really make sense. So if you would want to win the game, get the name, evidence. Well, we're taking one quick break, but before we go, yes, can we have our question on so people can chew on before I come back to give the opportunity for people to answer. Agatha is the dependent partner of Kofi Macho, a healthcare worker with 3 years of leave to remain. Agatha went to a GP with bruises and a bloodshot eye. Oh, what happened? She reported that her husband, Kofi Macho, hit her for refusing to turn off the TV. Oh my days. Kofi, You are using your macho to bully Agatha. Eh? Kofi is worried that if she reports that, Agatha is worried. Agatha is worried that if she reports Kofi Macho, he will throw her out of her home, of their home, and her leave will be cancelled. Agatha is 6 months pregnant. She has no independent income, and she is also afraid to go back home. Agatha is the dependent partner of Kofi Macho, a healthcare worker with 3 years of leave to remain. Agatha went to her GP with bruises and a bloodshot eye. She reported that her husband, Kofi Macho, hit her for refusing to turn off the TV. Agatha is worried that if she reports Kofi Macho, he will throw her out of their home and her leave will be cancelled. As Agatha is 6 months pregnant, she has no independent income and she is also afraid to go back home. What can Agatha do to get independent leave from her partner and also claim support and accommodation? 3 different answers. Choose one. 1. She has to report Kofi Macho to her pastor, so they plead with Kofi to allow her home. 2. She can apply for support under the Migrant Victims of Domestic Abuse Concession, that is MVDAC. Or 3. She has to leave the UK because her relationship with her partner has broken down. Think about this, and when we come, I will test your knowledge. It's the Community and the Law brought to you by BWF Solicitors.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214-218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Well, thank you very much for sticking and staying. I always want us to together salute BWF Solicitors. And I need to remind you that if you have not been sharing the links, please start doing so, because we had a clear somebody who stood on top in January. We are looking at February, and we'll call it all that at the end of the year, and you stand a chance of winning the Senior Partners Appreciation Prize. So keep sharing, keep sharing, keep sharing, and I would say again, keep sharing. We have discussed sole responsibility and the recent refusals of many applications and how we can make them right. If you still would want to come in, I can give concession for about a call or so, 0208-493-7345. But in the meantime, I'll go back to my question. Well, okay, I see Sandra Fraser is doing her job here. The child becomes your skilled worker parent's son, according to the immigration. And explained that. And let me tell you, if you associate yourself with BWF Solicitors, you learn a lot and you are sharp. And you are always very sharp on your feet when it comes to some of these questions. Now, let's see what the question was and what answers I'm getting on the platform. Agatha is the dependent partner of Kofi Macho, a healthcare worker with 3 years of leave to remain. Agatha went to her GP with bruises and a bloodshot eye. She reported that her husband Kofi Macho hit her for refusing to turn off the TV. Agatha is worried that if she reports Kofi Macho, he will throw her out of their home and her leave will be cancelled. As Agatha is 6 months pregnant, she has no independent income and she is also afraid to go back home. What can she do to get independent leave from her partner and also claim support and accommodation? One, she has to report Kofi Macho to her pastor, so they plead with Kofi to allow her home. Or is it two, she can apply for support under the Migrant Victims of Domestic Abuse Concession, that is the MVDAC. And three, she has to leave the UK because her relationship with her partner has broken down. Well, I'm tempted to go for three. Why? Because obviously when you come with your partner on these special skill route, and in this case the care worker route, and your relationship breaks down, what are you doing here? Your partner says, I'm no more with you, then obviously you have to leave the UK. So to me it tends to be like, okay, I may go for three, but that's not me. The answer should come from you. So let's see what we have. I see Sandra Fraser is trying to participate now. Lauren Miss Papeku. Lauren says answer is B. Franklina Atabwating says answer is B. Okay, I've read Lauren Miss Spice one. Nanaya says number 2. Sandra Fraser says B. Nanaya, I've picked that one. Margaret Adu Mensa says B. Nyakua Amwa says number 2. Okay. Who else? Who else? Let's see what you guys have. Zero. Okay. Well, I won't ask. Well, if you can dare come in, and you can explain to me why you picked the answer if it's correct, I might go to my benevolent self and give you a prize. But well, let's see. We still have a couple of minutes. Joseph Sia says number 2. Mami Pokia number 2. Okay, thank you. Robert Jemfi, number 2. Wow. Okay. Loads of them. Lauren Mispa says, I chose B because there's no way the UK government would turn this woman away, as domestic violence is a big thing in this country and they will be more than willing to help. Well, she's also pregnant. Okay. Lauren Mispa, thank you very much. Let's see. Benedicta Kesua says number 2. Okay, thank you, Benedicta. Who else? Let's see who else. Kevin Asamoah, the answer is 2. Thank you, Kevin. Okay, Sandra Usua, the answer is number 2, sorry. Then we have Yarin Team. Number 2, she can apply for support. Okay. Very beautiful participation there. Number 2 is correct, but Agatha should look for me because I'm romantic, respectful, and that's what I saw earlier this weekend. I was in tatters. no, put that back. I still want to read it. Yeah, number 2 is correct, but Agatha should look for me because I am romantic, respectful, kind, and have good heart. Agatha, don't die. Search for me. Yeah, Kofi Macho, don't do that. You see somebody is running after your wife now. I saw this earlier in the week and I was like, well, that's some comic relief over it. Okay, let me go to Uncle Ben for the lack of time to see what our correct answer will be, Uncle Ben.
So the reason why we do the quiz is when you splash information, people see it, they chew it, and when you ask them a question, they regurgitate it.
Mm-hmm.
So the question is to help people be analytical of the information we've provided. So Mondays, we have the nuggets. Tuesdays, we have the quiz. And then Saturday, we have the answer. So the answer will come. That is why we're doing this. And we share it on all our social media platforms so that people can participate. And because when you analyze and you provide the answer, it stays in your mind. If a friend or a family member is going through the same problem, BWF said this. This is the nugget. This is the answer. So this is what I will tell this person. Do this and do that. because we like self-help. Our processes is to empower you, to inform, educate, and to share knowledge. That is why we're doing all this. If through that you want to come to us, of course you can. But the main focus is to empower the community with knowledge, information, and discussion. The first thing I want to look at is, first of all, what is the status of Agatha? So Agatha is here as a skilled migrant dependent. What is her situation? Agatha is an abused migrant by her partner, and therefore the abuse will qualify as domestic abuse. The other thing I want to look at is Agatha has reported to her GP, so there's some evidence eventually of, obviously, although it's what she says, but the next route is, has she got a redress? The Home Office introduced a concession for skilled migrant dependents and student migrant dependents. That concession has always been there for people who are on the route to settlement. So the new ones have added is a skilled migrant, economic migrant, and then the students. So we go to number one. Agatha has to report Kofi Macho to her pastor. So they plead with Kofi to allow her. Now, I will say that in our community, a lot of people will do this. I know as a fact. That is what they would do.
Yeah.
So they would do that. There will be pressure.
Not to take the wind out of yourself. Sometimes people think that when they have quarrels with their partners and there's some form of violence and battering is okay, it strengthens their love. But I am telling you, and I'm looking in your face and saying that even if you believe in that, it's dangerous, don't do it. And pastors, please allow the Lord to take his course.
And then the second is she can apply for support under the Migrant Victims of Domestic Abuse. That is enticing. Let's look at the third one. She has to leave the UK because her relationship with her partner is broken down. So we do elimination by substitution.
Yeah.
The first one, I will never advise. So that one is gone. The second one, let's put it down. Let's stay. So that will stay. The third one, because there's the number two, the third one cannot apply. So the number three has to go. So we're now left with number two. She can apply for support under the Migrant Victims of Domestic Abuse concession. Let's see what the answer is, whether I got it right.
The answer to this week's test is number two. The policy concession, MVDAC, as has been explained and all that, an eligible victim of domestic abuse, a period of 3 months, permission to stay independent from their partner, providing an ability to apply for recourse to public funds to enable financial support where required. Permission will only be granted on one occasion under a MVDAC to enable applicants to make any subsequent application or decide to leave the UK. So, Uncle Ben, yes, number two is right.
Number two is right. Yeah. Oh, I did very well. Thank you very much.
Well, those of you who said number two, you are right. But let me look at the answer that Lauren Miss Papiku gave. If you could put that on there. She said that I chose B because there's no way the UK government would turn this woman away, as domestic violence is a big thing in this country and they will be more willing to help. Does that explain the rationale behind the MVDAC?
No. The UK government will not help you if there was no concession. Even people who are suffering from cancer and they've got a few months to live, they usually don't give them any sort of support. I'm afraid as what it is, it's a temporary reprieve for 3 months and the woman is back on the street.
If she doesn't do anything.
If she doesn't switch, yes.
Well, do something if you find yourself in this situation. Speak to lawyers and people who know what they are doing. They may go through your cases and look at the options that will be available for you. And I'll recommend BWF Solicitors for this reason, in the sense that they know what they're doing, they know what options they may be available to you. So call them now on 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. And I'll go to our traditional bit where Uncle Ben will just give us a quick summary of what we have discussed this afternoon. Sole responsibility, the reason why applications are being refused, and then we'll draw the curtains down. Uncle Ben.
Well, thank you all very much for joining us today. We're very, very grateful that you always come to support and then you share the knowledge. The purpose of today is that we've identified that children are unreasonably being refused and prevented from joining their parents who are on the skilled migrant route. What we propose is that you make a solid application with supporting evidence. As Kweku said, evidence is a game. If you want to bring your child and you are the only parent here, there's a requirement for you to show that you have sole responsibility. Sole responsibility has no definition in law, but it means that you have not abdicated your responsibility, but you have delegated because of distance. So how have you delegated your responsibility? You need to exhibit how you take your decisions. Financial support is important, but it's not the only thing that you must show. You must show interest in your child's education, religious upbringing, health, network, and above all, how your child fares. So calls, telephone calls to your child, to the school, to the health center, clinic, pharmacy, to the church and mosque, scouts and clubs, all must be exhibited as part of the process, and always write a letter to explain the situation and why your child hasn't joined you and they're joining you now. We hope this is helpful. And next week, Thursday, Friday, Saturday, we are here again. Thank you very much.
And with a promise that we'll be back from the main man himself, I want to say thank you very much for joining and sticking around with us. I also want to say that we have enjoyed your company, so please come back again, same time next week. My studio producer has been Professor Ade. I want to say thank you very much to Sheila Ankara and Pat Mododu for the support, and also to the BWF Solicitors family here on the 4th floor of the Yana House. We have really enjoyed your support, and I can see all of you participating online with us, so it means that we're not here alone all by ourselves. You have stayed with us all through. Thank you, and we'll do that again same time next week. So until then, please be good, share the knowledge, and come back again.